Thank you for your participation. We appreciate you being here this morning. Today's program, What Every Realtor Should Know Before Listing and Selling a Homeowners Association, is brought to you by the Orange County chapter of Community Associations Institute. And I know the first questions out of your mind is, what's Community Associations Institute? Well, thank you for asking. CAI is a not-for-profit benefit corporation that was founded in Orange County in 1973. Since they've grown to an international organization of over 60 chapters and 40,000 members nationally. Their sole focus is on betterment of community association living. We have membership groups in the consumer category, so people who own and live in community associations, particularly board members who serve in their leadership group. We also have people involved in the management industry, so community managers. They're also able to get their education and credentialing through CAI, much like you do through Orange County Realtors. And then the last group is the business partners, people who help associations run. So legal advice, financial advice, contracting, maintenance services, etc. So these group of individuals work solely to keep associations functioning. Now, why are we here with you folks today? Well, full disclosure, I'm a recovering realtor. I haven't practiced in a long time, but it can come back anytime. And we find that in the real estate community, there's just not a lot of education available on HOAs and what an HOA is, how they operate, et cetera. They can be very complex. There's a whole body of law on it that we're going to get into today called the Davis-Sterling Act. So it can be very challenging because there's really no education for realtors on this. I went through all of the state material. There's no questions in the state licensing test. So it's an area that makes up a pretty high percentage of the population of housing stock out there, but there's not a lot of information for realtors. So we put this together as a program to help the real estate community know a little bit more about homeowners associations, how they function. So of course they can help their consumers. So I'm not going to bore you with all the legal details of East and Strasburger. I'm sure the people in your risk management department have done that quite enough. I just wanted to bring this up because you're going to kind of get to make new law today, and that is determine what is the level of due diligence for an association records. Because of course, East and Strasburger, as you know, is related to the physical condition of the property. And now, of course, we'll protect on the next slide, you have a responsibility to do your physical inspection of the property. However, in many circumstances with an HOA, the most important aspect of the purchase decision is the HOA itself, not just the property, because a lot of times it's literally just the walls inside. All the major components, roofing, plumbing, mechanical, etc., are the property or a responsibility of the HOA. So that's really where the issue is. So we're going to talk about this over the next couple of hours. We have Daniel waiting in line here. He's an attorney, got a lot of experience. Despite his youthful appearance, he's got more than a decade practicing HOA laws. He works exclusively with HOAs. But we're going to tell you the things that are important. One is to make sure you have an effort out there to get all the important documents to your clients. We're going to talk about the ways to do that through the escrow process, what's available to existing members, etc. But it's important that they have access to all these documents because it's an effort that they understand a lot of things. One is the use restrictions. You know, the reason it's a deed restricted property, common interest development, etc., is it has limitations on what can be done there. So of course, there are a lot of parking, usage restrictions as it relates to short-term rentals, etc. So you're going to want to make sure that any potential owner understands these. Then you're going to want to make sure they understand the financial condition of the HOA. We're going to spend a little bit of time today talking about finances and reserve studies so that you can help them make an informed decision on what a fiscally sound HOA is versus one that's likely to have a number of special assessments or significant increases into their regular assessments. And then last and certainly not least is we're going to talk a little bit about the insurance needs. HOAs are, of course, unique animals. Each one is unique. So we're going to have to talk about the insurance needs individually and the ideas and the programs that we talk about on what the individual unit owner is going to need versus what the association has and or needs. Some of the laws on these that there's minimum requirements for both HOAs, and of course lenders are going to have their own requirements as it relates to a unit owner. So we're going to talk about ways that the real estate community can understand this and guide their clients in the right direction. So with that, we're going to kick it over to law. As I mentioned, Daniel is an attorney here with Norbert DiNicolio. He's been practicing law in this field for over a decade. He's a well-respected author and one of our favorite presenters. So Daniel, I will take it over to you. I will do my best to keep up with where you are in the program.
You do a great job, Scott, and thank you for the wonderful introduction. As Scott said, I practice exclusively in this area of the law now. I came to Norbert DiNicolio, or its predecessor, from the litigation arena. And so later on, we'll be talking a little bit about enforcement issues. And it's interesting, the comparison between regular civil litigation, which I'm sure that some of you have dealt with, and then HOA litigation and enforcement. and how the Davis-Sterling Act kind of sets up the process to avoid litigation. I don't know if Scott mentioned this. I did see in the comments that there were some items in the chat. If you do have questions, please feel free to throw them into the chat or into the Q&A. Scott will probably do a lot better than I will about monitoring that, but we welcome those at any point. I would rather address items that you are interested in and that impact you than merely read off the PowerPoint and explain that. So at any point, if you have anything that you want to throw in here and have us discuss, then we'll do our best to touch on that as well. The first part that we're going to talk about is the differences in the types of common interest developments. And the first that we're going to do is the condominium. This is a legal form of ownership whereby the owner is granted what's in quotes as a unit. We'll get to what that is later, but usually it's the airspace within the residential unit. And then the remainder is common area that's held by all of the owners in common. The common area is usually, with a caveat that we'll talk about in a second, the building structure and the outside components. So you'll see that, you know, the building and everything surrounding it is usually held by the association in general. And then anything within the inside, if you shake it, is usually the owner's unit. Contrast that with a planned development. And that is a legal form of ownership whereby the unit owns the lot, the structure, everything on top of it, below, above. That's usually owned by the owner. And then there's a designation where the common area owned by all of the owners in general is then selected outside of that. So whether it be private streets within that area, the association sign, clubhouse, pools, those are generally designated as the common area. I'm gonna flip through a couple, Scott. There are other less common types. I'm not really going to touch on these. One, community apartment projects, stock cooperatives. The difference between a general ownership and a stock cooperative, rather than owning a portion, the owners thereby buy stock in the association itself, and the interest of the unit is tied to ownership of that stock rather than holding it directly. These are less common, so we're not going to focus on those. We'll focus on the ones that you commonly deal with. What is not a common interest development? Well, we hear the terms townhouse a lot. That's not a legal form of ownership. It's a descriptive term, usually used by construction, marketing. Occasionally we'll throw it around in the real estate arena, but it's not technically a legal form of ownership. These sections are usually either condominiums or a planned development based on how they're described in the applicable documents. The same for single family attached or single family detached. They're also not legal forms of ownership. So we either have condominiums or planned developments. And we'll talk about what really triggers the difference between those two in just a second. We talked about the different types. Let's talk about the law. I mean, this is why you're really here, but the law that governs common interest developments. The primary one is the Davis-Sterling Act. I'm sure you've heard about this before. This is where we go as lawyers to find most of the rules that surround our life here with common interest developments. The Davis-Sterling Common Interest Development Act was formed in 1985. It was renumbered and completely overhauled in about 2014. And it was interesting. It started out as about 25 pages in 85. By 2014, when they overhauled it and renumbered it and put it elsewhere, it had ballooned up to about 100 pages with a separate additional 100 pages dedicated to commercial interests, common interests. That it's changed quite a bit, and ever since then, every year there's going to be changes that have tweaked and adjusted that we all need to keep on top of. But the Davis-Sterling Common Interest Development Act covers most of the law. It describes maintenance responsibilities, how assessments are run. You'll see in there, there's a full section on how construction defect claims are managed, are brought forth, the notice requiring those, the timelines. It talks about membership votes, inspection of records. There's a full provision 5200 talking about what your buyers are entitled to receive from the association in terms of association records. All of that is in there. At this point, I'm going to plug really quick the 2022 Condominium Blue Book. This is one that can be purchased from CAI that will have the full act available to you. Not only that, it'll have other statutes also that impact HOAs, the corporations code provisions, vehicle code. There's a section in here that talks about various case authorities that impacts common interest developments. It's a very, very good source of materials in order to do that. I believe also, if you look in the chats, we've also been provided a link to a Dropbox where there's a copy of the Davis-Sterling Act or the civil code provisions that we just talked about available to you there for free, so you can look at that. In addition to the civil code provisions, there's also portions of the corporations code that impact HOAs. Most of associations in California are formed as nonprofit mutual benefits corporations. So prior to the implementation of the Davis-Sterling Act, the corporations code was where you went to find out how this was governed. And you'll see that portions of the corporations code, you'll see important sections dealing with elections. It also contains the importance of the judgment rule, which is essentially what board members need to follow in order to ensure that they're protected from liability. What are the key terms, key things that they need to do in order to make sure that their decisions are protected? That is implemented, that is described within the corporation's code itself. Another source of legal authority regarding common interest developments is the vehicle code. You'll see that we just had a question a couple of days here in my office. Under what conditions is the association able to have certain vehicles towed within its property? What type of notices need to be given out before those vehicles can be towed? And that's within the vehicle code itself, section 22658. So that's one instance where you go outside of both the civil code and the corporations code in order to find another applicable law. The other is the health and safety code. HOAs are subject to various laws relating to health and safety. One instance that we've thought of recently and that had to deal with is the implication for whether or not associations are able to regulate or have to allow daycare centers. You see that often we have certain individuals, certain owners within an association that want to bring in children and operate a daycare center. Well, the health and safety code indicates that needs to be allowed, subject to certain restrictions and licensing and size requirements. But you'll see there that despite what's in the various governing documents of the association, this statute trumps and says, yes, they're allowed within conditions to operate daycares. Other sources of authority, we talked a little bit about state sources. Well, we also have the federal sources, and some of the federal laws that impact HOAs are the ones listed here. And we list the first one, Americans with Disabilities Act. There should really be kind of an asterisk there because it only impacts on certain conditions. Now, you'll see that the ADA is tied to whether or not there are circumstances of public accommodations. And generally, HOAs are not considered subject to the ADA. Now, if they open certain areas of their community to the public, rent out the pool area, for example, or allow public parking in their parking structures, then they might also be subject to the ADA. Other laws, the Fair Housing Amendments Act, find that this is generally how those requirements against discrimination are brought within the HOA context. It's the Fair Housing Amendments Act, or FIHA in California, indicating that discrimination is not permitted within HOAs, and that extends to board member acts, management acts, vendors. That's where those items come forth. The bankruptcy code applies to HOAs, and then the Fair Debt Collection Practices Act. One of the primary responsibilities of a board, and certainly one of the primary obligations that your buyers take on when they move into an HOA, is the requirement that they pay assessments. Well, there are occasions where individual owners become delinquent, and those need to be collected. Well, the Fair Debt Collection Practices Act, or in California also the Rosenthal Act, applies and governs how an association is able to engage in collection measures against its owners. Well, in addition to state and federal statutes, obviously there is case law. The difficulty is, of course, we're not able to list out every single case that applies to HOA, and it's constantly changing. So this is where the legal, the attorneys come into play, but case law also contains an interpretation of the law, the statutes. It's usually based on a specific set of facts, and that's how it affects board decisions and associations. So getting legal counsel involved as to how this particular case interprets this particular statute, but be aware that that is also in the mix as to the legal authority that governs common interest developments. And finally, we have the association documents themselves, and these are all normally referred to as a combined system as the governing documents. We have statutes, we have case law, and then we have the association's governing documents, and we'll go through those at this point. The first is the Declaration of Covenants, Conditions, and Restrictions, the CC&Rs. Okay, we generally refer to this as the association's constitution, because it kind of gives the powers and authorities of how the entire community is going to be governed. Okay. It is a recorded document created by the developer when the association's created. And that's important to know, because by recording it, it means that your buyers and your sellers, the owners within the association, are deemed to already know everything that's in there. So occasionally we have situations come up where we try and enforce the CC&Rs, and an owner says, well, I've never received a copy, I've never read it. And because they're recorded documents, that doesn't matter. Okay, they're deemed to know everything that's within those, and by implication, there's a real responsibility at the escrow portion of the sale to make sure that the buyers receive these documents and are aware of their content. They're very difficult to change. Usually they're only made by a vote of the entire membership itself, which is itself hard to happen, because usually there's less excitement about coming out to vote in homeowners associations. And usually you'll see that most CC&Rs have a very high approval requirement, so that sometimes it requires up to 66 or 75% of the membership in order to approve changes. The CC&Rs contain restrictions, including use restrictions, ownership restrictions, the implications for how assessments are run, how collections and liens work with the association. And these covenants, when they are recorded, and because they are recorded, they're given a presumption of reasonableness. One of the primary cases within the HO arena is Nerstadt, which outlines that there are only very limited conditions when this presumption of reasonableness doesn't attach. And we'll see later on that is contrasted with the rules that boards created, the operational rules that don't have that same presumption of reasonableness. So that's the first document in the governing documents. One of the additional documents is the condominium plan. Okay, so for condominium projects, you generally have this recorded document that is created prior to construction of the projects, which outlines the engineering specifications of the project. But for me, this is where we go to see exactly where the responsibilities are allocated between the association and the owners, as far as maintenance and repair and replacement responsibilities. Now, earlier when we talked about the various types of associations, we said, it could either be condominium projects or developments. This is the document where we go to see exactly what the designation for a unit is. It will outline the various components that are considered to be part of the unit versus not part of the unit. And so this is where we see exactly where that box is drawn. Now, it can be drawn anywhere. One of the most fascinating things when I started within this industry is to see what I called a townhome, and went in to look and see maintenance responsibilities and found out that it was actually a condominium. But the condominium lines were what was normally drawn as a lot. Now, I don't know why they did it that. It depends on exactly what they were trying to achieve, and there's various goals and objectives. But the association up to that point had been maintaining the landscape areas around the residents because they thought it was association responsibility. And come to find out, it was part of the unit because of the condominium plan. And so it was the owner's responsibility. And so after decades, they had to switch up the way that they were handling and find a plan for how they could shift responsibilities. So this is why we go to the condominium plan, to see exactly who needs to do what and who has that obligation. The next document is a final subdivision or a tract map. And this shows the lot and common area dimensions for a plan development. It outlines exactly where the specific lot that we're looking for. It's also recorded with the county recorder. And it often lists and describes various easements and responsibilities of the various parties. One of the primary things that we look at when we look at the tract map is that it will outline various dedications and offerings that are given to the city for utilities and various rights and easements related to that, and the acceptances of the city. So this is where we go to in order to see whether or not there are certain setbacks or certain utility easements that go across the lines. We'll go to the tract map itself. Another part of the governing documents that govern the association is the Articles of Incorporation. And we generally refer to this as the association birth certificate, right? This is how the association is initially created. Now, back in the day, it used to be very extensive. You see that for some of our older associations, the Articles of Incorporation may have things that you'll normally see within either the bylaws or the CC&Rs. Nowadays, it's very streamlined. Okay? It'll usually have just the corporate charter. It has the true and correct legal name of the corporation. So this is where I go to find out exactly how the parties are going to be named if I do any litigation. It provides the information regarding the location and address of the agent for service. And then this is filed with the Secretary of State's office in Sacramento. The next document is the bylaws. So when we talked about the CC&Rs, that's kind of the roadmap and constitution for how the community rights are allocated. The bylaw is kind of the same document with respect to how the corporation is structured. You'll see that this will describe exactly how the corporation functions. It talks about various implications in terms of potential voting rights, the number in terms of directors, how officers are structured and what each of the officer responsibilities are. Occasionally, you'll see that it will outline various document inspection rights that the owners have. It could include member discipline obligations, and how enforcement is needed to be done. And then this last note that occasionally we'll see that bylaws are maybe attached as exhibits to the CC&Rs, but generally bylaws are not required to be recorded or filed. Even when they're amended, they're just required to be certified, and then those are effective within the association. So it doesn't need to be recorded. And finally, the last is the rules and regulations. Now, these are contrasted from what we saw earlier in the CC&Rs. These are the operational rules that are adopted by the board of directors themselves. Okay, and the reason why they do that is so that various specific rules can change as the community needs it. And we usually encourage our boards to review these quite often and change them as the community needs. If these are not documents that are required to be voted on by the they're not required to be recorded with the county. They are required, however, if the board wants to change them, to be sent out to the membership for notice and comments under the 28, it says 28 days notice as a requirement. And then the board takes those recommendations and suggestions and the response of the membership into consideration, and then decides at the next meeting whether or not they want to change or adopt them. If the rules and regulations are changed, the members are required to be notified of that. And then within 15 days, they're required to receive a copy of the new rules and regulations. So what's the difference between these? We describe the CC&Rs as kind of a constitution. Well, this is the exact same thing. If you look at this, you'll see that various states have legislation that they adopt for their specific areas. This is the same thing. The board of directors adopts rules and regulations for their community, but it's also subject to the authority that is granted within the CC&Rs. They're not allowed to adopt various rules that have no impact that don't fall within the authoritative scheme that is granted to them under the CC&Rs. So those are kind of the structure and the documents for exactly what type of law impacts our common interest developments. And so we're going to shift a little bit to enforcement measures themselves. And this is kind of where I'd like to pause just a little bit and reflect a little on my prior experience as a litigator. One of the things that has always kind of fascinated me about this industry, the HOA industry, are the amount of provisions in place to slow down and possibly avoid litigation. And you'll see that even though it's not a requirement to ramp up to litigation, you'll see that there are a lot of little checks involved to make sure that everything is slowed down and hopefully avoid that. And hopefully you'll see that as we go through these various procedures. Generally, you'll see that in terms of enforcement, as we mentioned before, there are procedures that are possibly already within the CC&Rs and bylaws that will govern. If they're not, most boards should and do adopt a set of procedures and guidelines for enforcement of their rules and regulations, for enforcement of their CC&Rs. If HOAs don't have this, they should. And it gives the owners the understanding of exactly the process that is going to be filed. One of the first processes for enforcement that associations used are violation letters. And this is kind of usually the joke that we see on YouTube about how violation letters are being sent out left and right. Generally, it's depicted as a negative thing. I see it as a very good thing for two reasons. First, as we talked about before, because CC&Rs are recorded, it's not always the case that homeowners know exactly what the requirements are that are within them. They might be doing something just because they think that they have the right or the ability to do so, in contrast to the CC&Rs and what they're required to do. Generally, these violation letters are the ability for the association to say, hey, look, we understand that you're perhaps maybe new in this association and that you might not realize this. Here's the provision of the CC&Rs that governs this conduct. And so it allows kind of an educational approach. And then the second one is it also slows down the process, like I said before. It allows that next step for there to be communication and possibly the ability to remedy the situation without further escalation. If that doesn't work, if the courtesy notice doesn't solve the problem, the next level is generally we see that the owners are brought before the board of directors for a hearing and potential enforcement activities, whether it be fines, whether it be a restriction of various membership privilege, such as being able to go to the pool, or something to that effect. The association is required to provide and follow various due process procedures. You're required to give notice in a certain amount of time beforehand. The homeowner has the ability to either appear in person or submit some type of a written response that the board is able to consider before making any type of decision regarding fines or suspension of privileges. One other item that's not included in here is that the owner has the right to ensure that these type of hearings are conducted in a private executive session rather than being open and obvious for all of the full membership of the HOA to see. And generally that's how most hearings are conducted. Assuming that the hearings and the fines don't get us where we want to go in terms of compliance, there are other options that are available under the civil code, and that is the option of IDR and ADR. And we'll start with the first one. Informal dispute resolution is essentially just a meet and confer process. It's let's get the parties together, let's slow this down. And oftentimes we see that maybe before this circumstance, the only communication that people have are letters flying back and forth making demands. Well, this requires the parties to come together and allows them to sit and actually say, you know, this is what the situation is. And I had one just a little bit ago about one of the violations, and that's exactly what had happened, is that letters had been sent back and forth and it was just escalating and getting hostile. And we just brought a board member and brought an owner together and sat them down. They were able to talk about what was really going on, calm stuff down, and actually find some type of a resolution. So an association must provide a fair, reasonable, and expeditious procedure for resolving the dispute. If the association doesn't adopt its own procedures, the civil code provisions have a set of default procedures that are enforced in the civil code. And those are basically items such as it needs to be done within an expeditious time frame, but primary among all of these is that an owner is never charged for this process. Free process that they're able to come forth and utilize in order to potentially resolve the dispute. One other option that's in the default procedure is that while an owner is not required to accept and conduct this meet and confer, if an owner requests it, the association is required to step in and have this meet and confer process. Now, if IDR or meet and confer doesn't work, there's other alternatives, and that is the ADR process, or alternative dispute resolution. Now, this could mean arbitration. It's generally not arbitration, binding or non-binding. Usually the process that's selected is mediation. Let's get a third-party neutral in here to look over and see exactly what the dispute is and kind of weigh in and try and bring the parties to some type of an agreement. Generally, that is not binding. There's not a requirement that things settle. It's just the opportunity, again, to slow things down and hopefully be able to resolve the dispute. And generally, in this type of circumstance, the parties split the cost of the mediation. The owner pays half, the association pays half, and hopefully they're able to come to some type of a conclusion that avoids any type of further enforcement requirements. If all of these various steps don't work, then the next step is litigation. Okay, and there's various types of litigation against the homeowners that an association may bring. Those could include requesting a temporary restraining order. Generally, this type of a case is one where something urgently needs to be either prevented or required. For example, let's say that a homeowner starts building a brick wall at the front of the property without getting the approval that's required in the architectural approval process. Then the association is probably, after a cease and desist, going to jump in and ask for a temporary restraining order requiring that process completely halt. You'll see this in other circumstances where there might be a health or a safety impact where something needs to be stopped right now. If it's not that urgent in terms of an emergency situation, then you'll see that there will be a request for preliminary or permanent injunctive relief. Basically, the court saying you needed to either do or stop doing X. And usually you'll see that there's a request that the owner bring that property into compliance by doing whatever provisions of the governing documents are in effect. There may be a request for damages. This is either whether you'll see that if portions of the association property was damaged and need to be fixed, but also if it's a situation where, let's say that there are fines involved that have not yet been paid, those will be generally collected through damage provisions such as this. And declaratory relief, which is essentially saying, hey, look, the parties have this dispute, they disagree over the application of this provision of the CC&Rs. Court, tell us what the CC&Rs mean, or tell us who's right between these two sides. And the court will step in and issue a declaration for those. So why all of these various different steps in order to avoid litigation? Well, the difference in HOA world versus most of the other civil litigation cases is the issue of legal fees. In HOA world, when you have an enforcement complaint, the prevailing party by statute under the civil code is able to collect those legal fees, or at least a reasonable, whatever is reasonably determined to be the legal fees and costs. That's not something you generally see within litigation. Usually under the American system, then each side pays their own legal fees. But in this circumstance, the prevailing party generally collects that. Now, how does that impact? Generally, when we get to this point, the legal fees exponentially skyrocket, and it becomes almost impossible, it does happen, but almost impossible for settlement to occur by the time that you've filed the complaint. So there are all of these built-in various steps in order to avoid this process, in order to avoid litigation, so that the parties can hopefully find a way to reconcile and resolve the dispute before we get to this portion. If for some reason a litigation begins and is initiated, what are the various defenses to enforcement? And I won't go into all of these in great detail. Laches essentially means that it was brought too late. Waiver and estoppel, one of the parties has done certain things that eliminates rights. The conditions might have changed by the time that we already got that. The big primary ones that probably your clients, buyers and sellers need to know are the selective and inconsistent enforcement arguments. And this goes back to the issues of the CC&Rs and the rules, that one of the primary requirements that boards take on and shoulder is that enforcement of these regulations is done consistently. It's not arbitrary, it's not capricious. It's not because I don't like Joe, but I love Jim, and so I'm going to enforce against Joe, but not Jim. It's that we enforce them consistently throughout the association. You're going to see number 8, conflicts between governing documents. This is what I suggested before, that if the board adopts certain rules that are in conflicts with the CC&Rs, well, the CC&Rs are going to govern and the board's not going to be able to enforce those rules. They're going to be deemed invalid. And then discrimination. Again, there has to be a consistent enforcement. We can't just discriminate because we don't like somebody or because of certain other various protected classes. And those are the various defenses that are commonly raised inside the litigation context. One other item we mentioned previously is the issue of standards of care. And I'm not going to go too far into this, but we talked about how arising out of the corporations code is this idea that the idea of the business judgment rule. And essentially what this means that boards are protected as long as they're utilizing good business judgment. Now, what does that mean? It means that they need to be acting in good faith. We can't have that direct attack that we talked about before, as far as I don't like Jim, so I'm going to do this and decide this way. There must be a reasonable inquiry or investigation. So our board members are voluntary. They're not experts. They don't know various areas that arise out of different circumstances within the HOA. And so they're required to rely upon experts, whether that mean a plumbing contractor, an insurance agent, a reserve specialist, legal counsel. They go out, they inquire, they investigate, they get the opinions of these experts, and then they come back and they make a decision in the best interest of the community itself, not the individual directors, but the community as a whole. And if they follow these processes, then the court is determined, or the law is determined, that courts will defer to those business judgments. Now, what does it mean if they don't follow this process? It means that they're not protected. It means that the court doesn't necessarily defer to those decisions. And so if those decisions are challenged, then they become subject to that attack and might not be upheld. And the Behan case is an interesting one that goes into the various aspects of whether or not an association is required to litigate. Okay, and the answer is not necessarily. Okay, and it comes into whether or not this business judgment rule applies. If the board of directors gets charged with a potential complaint, they, in good faith, investigate and try to determine whether or not litigation is necessary or required. If they find out that, oh, look, we're looking at a very small potential impact of the rules, say the trash cans are being left out maybe an hour or two later than trash pickup in violation of the rules. Well, as you know, and as we've discussed, to go into litigation is a huge financial commitment. So is an association required to bring a lawsuit against every member that leaves their trash cans out too long? No. If the board investigates and looks into that and talks with legal counsel and determines that that's not a good financial commitment, then even though the next door neighbor probably has an issue with those trash cans being left out and wants the litigation to take care of it, it's not necessarily the association has to initiate litigation for that issue. They have other tools that they can make an affirmative decision to use instead in utilizing their enforcement. And so that's kind of the standards of care that a boards need to utilize in order to make sure that their decisions are protected and deferred to. One other aspect that we want to touch on really quick, and this is primary for what you have, is the issue of transfer disclosures. If you look inside the civil code, primarily 4525 through 4545, and we can't go into detail onto all of these, but it outlines the various requirements that come into play when there is a sale of the property. We're going to have Scott, if you could switch a couple in advance.
Those slides, that's an old slide. The next slide you'll see is for insurance.
Oh, Oh, well, then I'll just discuss it really quick and then we'll have.
And wanted to point out, we gave you the entire Davis-Sterling Act, and that was part of the reason why, is so that you could see section 4525 on your own. There's many provisions in there. I would like to just point out that one of the challenges that we hear from the real estate community is that it's expensive to get these documents to escrow, and that's true. But selling a home in California is expensive. The reason that you want this process is you don't want to be the link in between. We're going to talk about this in some of the other sections as it relates to information, but an HOA is required to send out a package. It's the annual disclosure package, and it's set full of financials, all of the documents that Daniel's just spoken about, your CC&Rs, policies, et cetera. It is in this package. And so the logical explanation is, well, just take this package and give it to a potential purchaser. And by the way, the law has those provisions. Dan was going to talk about that. But yeah, if you are an owner and you are in possession of this material, you are required by law to give it to the prospective owner at no charge. But the problem with this information is it can be dated. If you go back just a little bit, Dan talked about that 28-day rule, the 30-day rule. So the board can change the rules and regulations. That wouldn't be reflected in that. Of course, financials are only good really on the day that they're printed. So all that information is going to be old and stale. So it really behooves the real estate community and a prospective purchaser to pay the monies to get the information from it. Now, the civil code will also say that this information is to be paid for by the seller. The reason it says that is that the HOA doesn't have any responsibility or authority over a real estate professional or a prospective purchaser. They do over an owner. So if they're going to go and produce these documents, and there are fees that are actually regulated so that they're reasonable, as it were. So if they're going to have to pay these fees to produce these documents, get them to escrow, and then the prospective purchaser, then of course it can be negotiated in the contract. The reason that the HOA wants to make sure that the seller is known as responsible is that's where they can collect their money from, and they know they can get that. So it can be negotiated, but it's listed in the civil code that way. But you want to get updated information so that your seller and you, the individual real estate professional, are not in that chain of custody, as it were, that they're getting it straight from the escrow, and that escrow has gotten it straight from the source, in this case, the HOA, which would be the most current document. So we know that can be a bit of a challenge to go through that process, and obviously expensive, but it really behooves everybody to get good updated information because, as we've talked about, they're subject to change. And when we talk a little bit later about the financial sections, we'll talk about some specific information that you can get. With that, before I let Daniel go, because I know you've got a couple of questions for him, the role here is not to try and change you into mini Daniels or anybody else. It's to show you where this information is available. And if you have questions, again, it's going to come up a few more times, but cai.oc.org. That's our website. We have literally hundreds of professionals in the industry. So if you have a question about governing documents, rules, regulations, there are attorneys, there are property managements, other professionals who would be happy to walk your consumers through these processes. I can just tell you that most of the people in the industry have a kind of a 15-minute rule that if you call up and you ask questions, 15 minutes is free. After that, they may start ticking the tab on you. But generally, you can call up and ask questions. And also, anybody who produces a document out there, so whether it's a law firm, a CPA firm, a reserve study firm, if they have a document and your consumer is in receipt of that, they can certainly call the issuer up and ask them questions. I mean, we're happy to spend a few minutes explaining what our report does. Remember, we're in business too, and these future members, that's our future business, right? Because a lot of these people are going to wind up on boards of directors. They take an interest in their community. They make decisions on what attorneys they're going to hire, what reserve analysts, what CPA, what management company. So you'll find that the industry is pretty generous with its time when people have information and a lot of questions as they're making a purchase decision on either side. They're about to sell or they're about to purchase into an HOA. Again, you go to the website, have literally hundreds of practitioners that will be happy to help walk them through it so that they have a good experience, because in all, everybody who lives in an HOA is our constituents. Daniel and I, we serve on the education committee for CAI. So anybody who lives or works in a community associations institute is literally our constituents, and we're happy to help them wherever possible. So with that, I think we see a couple of questions. I'll read them off here if Daniel can't see them, but how can you tell if assessments are coming because they have not been put aside enough money for repair? Anonymous attendee, that's a good question. In a little bit, we're going to talk about the finance section and reserve studies, and those will give you the best clues on how to do that. To Daniel's point, Daniel, can you explain what would be required for them legally in order to process a special assessment?
In order to do a special assessment?
Yeah.
And it depends on exactly how much of a special assessment. Now, we talked a little bit about the various civil code and corporation codes requirements. In very broad strokes, if the assessment is 5% or more of the budget for that year, then that is one of those instances where it needs to be sent to the membership for approval and for vote. Otherwise, it's within the purview of the board itself. Now, there are certain exceptions to that, dealing with emergency situations involving, like I said, health and safety. If there's something that needs to be taken care of right now, or somebody's going to be injured, or there's going to be property damage, and the board just doesn't have time, then those can be implemented and handled. There needs to be various resolutions that still need to be passed that go out with a special assessment. But in general, the key is that 5% mark. And you'll see that will be compared with the annual budget that goes out each year.
Okay, well, thank you, Danny. I appreciate that. Like I say,
Of
we're
course.
going to have a little bit more on that in the financials and reserve sections, but there are limitations on what boards can do. Also, as it relates, Daniel mentioned about the policies and procedures. So, if you don't like that the laundry room has to shut down at 9 o'clock, well, that's within the board's view. There are very few CC&Rs, and Daniel, correct me if I'm wrong on this, very few CC&Rs that will get into the operational level. So the hours of the pool, the laundry room, the rec room, all of that is generally within the peer view of the board, which means it's in the peer view of the membership, because of course membership elects the board and they are eligible to run for the board themselves. So, as they say, if you don't like something, well, you can run for office as well. So as it relates to the things that a board can change, there's a whole group of policies and procedures outside the CC&Rs that are very important that you want to get updated on a regular basis.
Yeah. Generally, we see that the CCRs just give the broad stroke general policies and authorities, and then everything else, like you said, Scott, is going to be the operational rules that the board is able to change and hopefully change and adapt as the community needs those type of changes. Occasionally, we see that CC&Rs, an association is created many decades ago, and things have changed significantly in the world since that association was created. Well, hopefully that those items are also being changed and adjusted each year by the board with their operational rules.
Yeah, and that's good. And we're going to talk about it a little bit later. But while we have Daniel here, I think one of the most valuable documents for an HOA is to have a maintenance metric put together. You have an attorney who reviews the CC&Rs, the condominium plan, whatever other information is available, to determine who is responsible for what. So the doors, windows, other common area components. If there's no delineation between, hey, you're responsible for this versus the HOA, then there can cause some confusion. So having an attorney go through the governing documents, identify the components that are maintained by the association, those that are maintained by the individual homeowner, putting them down into a form. That way it can, of course, be shared with a membership, and it can be shared with other people involved with the process. So, your service providers, your painters, like, oh, by the way, don't paint that. That's not your responsibility. The reserve analyst, hey, you don't have to include that. That's not their responsibility. So that's probably, if you don't have one, most of the newer communities, I think, do have them. But if you're in an older community and you don't have one, I think that's a good use of community resources, to spend the time and the effort and the money to pay an attorney to go through your documents to create that. At the same time, they'll be able to tell you where your documents may be outdated. Daniel mentioned this at the top. The Davis-Sterling Act came in 1985. It's been amended over 130 times since then. So as you can see, it gets multiple amendments every year. Back when I started, it was about 5 pages long. It's now up to about 140 if you print it out. Again, you can see the Davis-Sterling Act, pull it out from the chat box there. You can see how many pages it is. It's quite extensive. So a lot changes over time. So it's important to have your CC&Rs reviewed, because there may be some provisions in there that are no longer applicable, that have been changed by the change in the civil code. So it might be time to update that. I've got another question. I live in a condo and we have an HOA. My home has a wall which the HOA is supposed to fix, but HOA say my trees are the reason of a cracked wall and needs to be fixed. This is a home built 30 years ago, and how can we say my trees are the reason? Of course, trees are not touching the wall at all. How can I react to the HOA? I will give that one to Daniel.
Well, and I want to make sure that we understand that we're not able to give legal advice at this point. So it needs to be kind of a general situation. One of the things that we talked about before is the component analysis, particularly in a condo situation where there is going to be a condo plan that discusses exactly where the boundaries of the various units versus common areas and potentially exclusive use common areas, which is another term that we haven't even gone into, are at. But one thing that also comes into play, and particularly in situations like this, is that even though that there are particular components that may fall under one side versus the other, there's also the issue of potential negligence that gets involved, which changes responsibilities between the two parties. In this type of circumstance, I would say that because I don't know your documents and how they play out, and specifically the CC&Rs and the condo plan and what's designated what, I really can't speculate as to how things should be handled on this. And I would say that go find somebody that is knowledgeable, not just in civil litigation, but also in HOA law, to be able to look at those documents specifically and address your particular issue.
Yeah, and I may also recommend that you, if the HOA hasn't engaged the service of an arborist, that they engage the services of an arborist to show cause. If they're making a claim that this tree that's on your property apparently is causing damage to common area property, then what cause do they have to say that? Is that just based on the opinion of Bob, the board member who's not an arborist, or is that based on a professional opinion by somebody who has more authoritative information? So I would also ask them to tell you how they made the determination it was specifically your tree. That's
the business judgment rule that we talked about before, the importance of getting experts involved on both sides of it, but particularly for boards to be able to do that, to make these decisions, because they're not arborists either.
Right, exactly, and that's why you always want to, we work on both sides of this table. We want to make sure that HOAs are being honest with their membership, and that membership's being honest with their HOA and their representatives. So yes, if they've made a claim, that's fine, and that may actually be the case. But you need to investigate a little bit more. And how did they come to this determination? Was it based on the advice and rule of experts, or was it just their first thought process because your tree happens to be the closest to where they see damage? So certainly holding them responsible to give more detail on that would be the first order of business, and then take it from there. Okay.
And I did see that there was a follow-up question about whether or not they can receive the investigation documents. Homeowners are entitled to a very limited release of certain association records, and that is found. There's a list of that, various categories in Civil Code section 5200. And then right after that, there are a couple of provisions that indicate how long they have to give it to you, and exactly the process for giving it to you and the implications if they don't. But 5200 details the ownership rights to release of association records.
Yeah, very good. And thank you again. Give me the chance to plug again that we've given you the Davis-Sterling Act. We believe it's very valuable. It has very specific information. Generally speaking, most of the records should be available within 10 days. So if they've had the property reviewed, again, just hypothetically by an arborist, well, then that report should be available to you within 10 days, subject to redactions on certain information. But yes, that 5200 and et al. Will give you the information on what you can expect and the timelines that you can expect it. And certainly if they are going to use it as quote unquote evidence against you to levy a fine or cause you expenses, then yes, they would certainly want to be able to share that with you as early as possible. So I would ask the association for whatever information they have used to make the determination that they have. I hope that answers that question. She got it, thank you. So yes, I think we did that. Okay, with that, any other questions for Daniel? If not, again, CAI.org, CAIOC.org, excuse me, California Association, excuse me, Community Associations Institute Orange County Chapter. If you have any
Got it.
questions on any legal fees, on any legal issues, don't hesitate to give Daniel a call. You can look up his firm, Norberg and DeNiclio. They've been doing this for, I think, 40 years. I don't want to out Dan on his age too badly, but they're one of the most experienced and well-respected firms in the industry. And so we appreciate Daniel coming in and offer his expertise. And you can, again, find him on our website if you have more questions for him. So with that, Daniel, thank you very much for your participation today.
Thank you, everybody. Appreciate the time.
All right. Thank you for that. Okay. Our next section is on insurance. I'm going to do this as best I can on memory until my buddy Patrick comes in. But insurance is a critical part of the HOA world. Specifically, why do we buy insurance, right? Well, we do it for a number of factors on what the determination is why we buy. So there are some very basic civil code requirements for HOAs that we'll cover in just a moment. And then, of course, each individual lender will have their own requirements on what they're going to require. So assuming that most of these properties have a mortgage taken out on them, you're going to have the requirements that are put forth either by the governing documents, the civil code, or lenders. So why it's so important to talk to somebody who has a deep experience in this and understanding the needs. So the state statutes you can find in the Davis-Sterling Act. So again, plug our handout to you, go download that from the chat box, and you can look at the governing documents on your own individual community and compare them to the Davis-Sterling Act. The governing documents will have a very specific section on it. So wherever you are in the governing documents, it will say where you're going to need to find that information. And again, most lenders publish their information on what specifics they're going to require for individual process. Oh, and look at that. My savior is here. I've only had to do one slide and I only messed it up probably a little bit. So with that, I'd like to take this opportunity to introduce the real insurance guru. Oh, that's all right.
You guys are a little ahead of schedule?
Yeah, we're a couple minutes ahead of schedule, so it's no problem at all.
Okay, sorry about that.
And that's fine. And by the way, keep your questions coming. I will be on the whole time. Daniel likes to listen in, and we always learn a bunch from this. So if you have questions, please continue to put them in the chat box. We'll do our best to answer. If it's insurance specific, we may answer it, or we may wait till Patrick is done with his presentation to talk about it. But Patrick Penderville is the insurance guy in our industry. You probably know that insurance is going crazy in California. You've got the wildfires, flood, earthquakes, et cetera. So it's a very volatile market. It's especially volatile in the HOA market. So I know that some of you online now have probably had transactions either come to a screaming halt or have to take a detour because of the insurance requirements. So Patrick will explain some of what's been going on locally, statewide, meaning on that issue, and then some just general information as it relates to insurance. He is, by the way, born and bred Orange County, went to La Habra High School, and currently lives in South County. So he's every all-American boy, Orange County. So with that, Patrick Penderville, Penderville Insurance.
That is a great intro. Thank you for that. Written by my mother, probably. All-American boy. Hey, so yeah, can I just talk about this whole insurance market? I will tell you this. I've been an agent for 35 years. This is by far the most firm market that we've seen. I mean, and I've been an agent long enough to go through the Northridge earthquake and all the ramifications and fallout from that. This is by far the worst. We have homeowners associations. If you're in any kind of an area that's a wildfire area, the premiums are going completely bonkers. It will affect ability to refinance and to buy, because what we're having to do is we're having to give them less limits than they need. So for instance, you might need a total insured value of, say, $60 million, and the market can only get them $5 or $10 million. Oh, and by the way, it's hundreds of thousands of dollars in premium. So it is a real problem, and it means that when you sell a unit in that area, it's really tough to get financing. So you have to be really mindful of any kind of association that's in a wildfire area, and you'd be surprised what they deem to be wildfire. Much of Rancho Santa Margarita is deemed a wildfire area. So be very mindful of that. And there are some tools you can use. You can always call an insurance agent and ask them, but they can run these tools that will tell us what the risk meter score is, because that's the most popular one. The other thing is, if you have associations with lots of claims activity, they also run into problems. So the insurance companies are just super quick now to take accounts that are in a wildfire area or even a heavy brush area, and then also high losses, and they're just going to non-renew them. That is what's happening. And so that is a really, really big problem. So Scott, did you get through this slide?
Yes, I did.
Okay, very good. All right, so let's go on the next one. So everything is controlled in California by the Davis-Sterling Act for as far as limits go, as far as your liability limits. For instance, on the right, they've got these situations where if you have over 100 units, you need to have over $3 million. That's the B. If it's under 100, then or 100 or under, it's actually $2 million. This case comes from out of Dana Point, California, in the late 80s, where somebody was walking up the stairs. She fell backwards. She sued the association for all of the insurance they had, which back then was $1 million. That was customary. And what she had is a situation where she needed more money. So she sued every single homeowner. And so basically the Davis-Sterling Act came in and said, look, if the association has these minimum limits, the homeowners cannot be sued personally. On the left is the directors and officers for their limits. You can see it's 500 and $1 million. Really, it's a misnomer because every D&O policy is going to have at least $1 million, regardless of how many numbers of units. So it's just a super important. Where you will see this is if you ever deal with an HOA that is not managed by a professional management company, like maybe it's a 6-unit building, it's just managed by the board of directors, those are the ones that might get tripped up on this. So you have to be careful on that to make sure that they actually have the minimums in order to keep it so that the homeowners cannot be sued. And then also, this one is for fidelity bond. Now, this is something we had been doing for years, but one of the last bills that Jerry Brown signed was this law, and basically it codified the rule that we were using reserves plus 3 months assessments as your fidelity bond limit. So every association should have that. Take all reserve accounts plus 3 months assessments, and then you have your limit. The other thing about this is that what Jerry Brown added is they included electronic theft of funds. So basically, I had a really bad situation happen. It wasn't one of my clients, but someone called me for advice. And it is a local company here in Orange County. I'll just tell you real briefly what happened. They got a computer hacker got into their system, figured out who they were doing business with. They then created an invoice from that vendor. They then sent that management company from that vendor, supposedly, a bill for $17,000 for work that they had supposedly done. 100% fraud. Okay, it's called social deception. The management company unfortunately paid it. And so now we're trying to unwind it and see who and where is this coverage going to come from. So it's becoming a really tricky world, but you want to make sure that all of your money electronically is covered. And I emphasize this because not every insurance company is up to speed on this part. So you have to be real mindful and quiz your agent, say, are we covered for electronic theft of funds? As far as the other requirements, you also have the governing documents, which is really where we spend a lot of time, going through. Sometimes the CC&Rs are not super clear, but it's going to hopefully show who has the ownership interest in the actual building. Is it a homeowner policy for it's a PUD, or is it an association for a condo or a townhome? Is it a cooperative? We look at the maintenance and repair obligations. For instance, is the association going to be responsible legally if the roofs start leaking, or is that not their liability? If it's not their liability, it's going to be a much more favorable rate for them. And certainly we look at insurance obligations. We look at insurance obligations for not only the exterior, but more importantly, actually the interior, because that's where most of the disputes come up as far as bare walls, walls in, or all in. I think we have some samples of that here coming up. Okay, so then we will also look at insurance for the lenders for the flood insurance, and then commercial insurance for HOAs. So it's important to know that an insurance policy is like a coin. Right? A coin has a heads and tails, but it's the same coin. An insurance policy has a property insurance section and has a liability insurance section. The property insurance section is basically a first party damage, such as, my house caught on fire would be the most blatant example of that, or something got stolen or vandalized. So basically it's a sudden and unforeseen loss, especially when it comes to water damage claims. It has to be sudden and accidental. But then on the other side of that coin, or the insurance policy, would be liability insurance, and it works differently. Okay, so it's a third-party injury and damages. It includes hurt feelings, which is libel, slander, defamation, and the key is that you need negligence. So I'm just going to give you an example. I'm going to give you an example of a real claim that happens very frequently that starts off as a property claim and then goes into a liability claim, and that is a leaky roof. Okay, you have a leaky roof, comes in, damages the drywall and the interior of the wall and maybe the flooring. And so that is a property claim. All right. There's no question about like whose fault is this? It's just only like, is the leaky roof covered? Yes or no? Well, unfortunately, the answer in most cases on that is no. Why? Because it's not a sudden and accidental. It's something where it's tied to the old roof that wasn't replaced in time. So now you have all this damage. You're looking at a property insurance claim that's not covered because it doesn't trigger the peril, not because anyone's at fault. It just doesn't trigger the actual peril because a leaky roof is not the part of the perils. And perils, loosely defined, are the things that trigger insurance benefits, such as fire, theft, collapse. Those are perils. Leaky roof is not one of those. So what it does is that you still have all this damage. So where that claim usually goes, if the association is responsible for replacing those roofs or maintaining them, it goes into a liability insurance. So now it's a situation where it's like you need negligence. Well, if the unit owner can prove, hey, the board has been completely negligent in not taking care of these roofs. These roofs are over 20 years old. They haven't done anything. We keep talking about it. And of course, I'm making this up for, the more dramatic effect of you really point to negligence. All that damage is going to be picked up then by the liability insurance policy under the understanding that the board was negligent in not taking care of their fiduciary duty, which is to take care of those roofs. And so that's an example where you have a simple roof claim goes from property to liability. Again, no fault in the property. You could be smoking in bed, which is completely negligent, burn your building down, and it does not matter that you are at fault for that. It's the fire is covered because it's a peril. Liability insurance is all about who's negligent or is there negligence. On property insurance, we have this policy that you'll see a lot called special form. And basically what it means, it's not a named perils policy. So a named perils policy through, for instance, California Fair Plan is really limited coverage, just super basic. Special form widens the number of perils, and it opens up the net for more perils. So you'll see special form most times it's going to be fire, theft, collapse, vandalism, so on and so forth. Then you have the property insurance, fidelity and crime, which we mentioned. It is already a part of the property policy as well. And then, of course, you have earthquake insurance, which is a good idea for people to look at, by the way. And if you're serving on a board, my advice to you is to check it out, get a quote, even if you vote it down. It's better for the board to vote it down and have discussed it than to completely ignore the subject. You can certainly vote it down if you think it's in your best interest to do so, but have the conversation. And of course, flood, a lot of Huntington Beach and Long Beach area, maybe some parts of San Capistrano, there's flood zones. Those are very expensive policies and hopefully you're not in a flood. But if you're selling a place, keep in mind, if they're in the flood zone, if you see them in the documents, just warn your buyer that there's going to be a flood insurance premium in addition to it. So be very mindful of that. It's not cheap. So we're now going to talk about the walls in coverage. I mentioned earlier that the CC&Rs dictate what we have as far as the interior need. And so basically we go to the CC&Rs, we look at that. There are three options, and the three options here are illustrated. One is bare walls. The second is single entity, also called walls in. And the third is all included. Now, so I'll define each one. So the HOA under a bare walls policy, the HOA insurance policy is going to cover the exterior coming into the unit up to and including the drywall. So there's going to be a subfloor, but there's not going to be coverage for flooring, cabinetry, plumbing fixtures, electrical fixtures, built-in bookcases, things of that nature. It's just simply bare walls right up to including the drywall. Single entity, again, also called walls in, it would go to the original builder specifications or equivalent replacements. So for instance, if the builder put down tile as the floor, then they would get tile back. If the homeowner or a previous homeowner upgraded the flooring from tile to, say, hardwood, for instance, then their insurance policy, insuring their actual condominium, that would pick up that difference. So it's called single entity, and that's a very, very popular option. So you go to builder's grade on the single entity walls in, all upgrades are covered by the unit owner's policy. Then we have this other one called all included. Now we don't have too many of these. There are on the more rare side, but they're enough to be out there and you'll see them all the time. So there's not like they're super rare. It's called all included. And basically what you would do is everything that's been added to that unit, whether it be from the builder, the current unit owner, or a prior unit owner, is covered by the association policy. Literally, you can, look at everything inside there. And this analogy that's written here is if you were to pick up the building, turn it upside down and shake it, everything that sticks to the building would be covered by the association policy. That is, that's fairly accurate. So basically flooring, cabinetry, plumbing fixtures, electrical, it doesn't matter what they put in, it's all included. Of course, everything is subject to the HOA's deductible and the policy limits. I want to mention something about your deductibles, which is we always advise associations if they don't have a formal rule on who picks up that deductible, then you want to make sure that they are talking about that at the board meeting, talk to the general counsel and pass that rule. Those deductibles should be placed on the individual unit owner. The reason why I say that is because it's to their benefit that the insurance policy is being used, and their own HO6 policy is going to cover those deductibles. So it's very easy for the association to not make the unit owner responsible for it, but shift the cost from the association to the individual's insurance company. So I would really recommend you do that. How this is all different from HO6 is basically an HO6 comes in and takes care of the gaps. If you have a bare walls association policy, you're going to have an HO6 policy with a lot of building interior. So it's because it's going to take care of flooring, cabinetry, plumbing fixtures, electrical fixtures. As you go down this list, the need for the personal insurance dissipates, but it never goes away because the HO6 policy picks up everything that the association policy leaves off, plus the deductible, plus the personal property, liability, loss of use, loss assessment coverage. So an HO6 policy is not competing against the HOA, it works in concert. The HO6 policy we refer to because that's the insurance code language for it, but commonly it's referred to as a condominium unit owner's policy. By contrast, an HO3 policy, also a Department of Insurance term, it would be referred to as a single family homeowner's policy. And basically, I just kind of went through this. I guess we can kind of go over this, but there's a little snapshot of everything that's covered in your HO6 policy: building, personal property, liability, loss of use, and loss assessment. Then, of course, we have fidelity, bond, and crime. It's sad when we get these claims that come in. It happens more than you would think. It doesn't really hit the papers very often, but basically, it's just basically good old-fashioned employee theft or embezzlement. As far as who is an employee, it's a rather broad definition and includes volunteers, of course. There are other insurance agreements we have to worry about from time to time, but that just kind of separates company A from company B from the insurance side. I mentioned the social engineering and deception fraud a little early. That's where it should have been, but basically that is a big deal. You guys have to take care of, if you're involved in the management of an HOA, if you're a board member, you have to be careful on who is sending invoices over to you. Be very mindful that that is a really growing trend. The limit requirements on the Davis Sterling, we already mentioned that, but it's basically the reserves plus 3 months assessments. That's how much you need to have on that. Sometimes your CCNRs will have a higher limit. If they do, then take the higher limit. So it's whichever is the highest. So liability insurance, this is turning that coin and talking about, third-party bodily injury, property damage, personal advertising. I will tell you the most common claim on a general liability policy, for sure, without a doubt, is trip fall. Okay, we get them all kinds. I mean, everything from a twisted ankle to literally death, unfortunately. And so that is by far the number one. The second one after that would be damage to unit owner's property, and that would be under the property damage section. Personal and advertising injury, we've got situations where it's libel, slander, defamation. It doesn't come up very often, quite frankly, but an example would be you have a board member who's talking about somebody who's late on their dues or their assessments, and maybe they say something that's slanderous. That would come up, but it's pretty darn rare that does happen, but it's possible. Cross-complete operations, people talk about that a lot because it's on certificates, and it doesn't necessarily really apply to an HOA unless you had a product that you're developing. Most do not. Most are just simply condo associations and homeowner associations. Medical expenses, that takes care of any kind of trip fall claim that where you're not deemed at fault. So basically, here's the way it works. Somebody trips on the property, the insurance company has a claim open. The insurance company might reach out to the person that tripped and said, hey, do you have any medical bills? We want to take care of that for you. Here's $1,000 for your medical bills. It's fault-free, meaning we don't have to admit negligence on that. And what we're trying to do is dissipate the chance of a lawsuit coming by taking care of the person early and quick. The theory is pay them $1,000 now, they'll be happy, it'll go away. By contrast, if we don't pick up maybe some miscellaneous medical bills, then maybe they get angry, they start having to deal with it on their own. Maybe they're going to hire an attorney now, and they turn a claim into a much bigger claim. So that's the reason why we have a little medical expense there. Some people, when they look at the HOA insurance quote, they'll say, hey, that's $5,000 for medical expense. That's nothing. And it's like, well, the reason why it's so low is because when it goes past the medical expense, it goes into your liability. And so there is more coverage for the injuries. Auto liability, we don't have a lot of associations typically with vehicles, but it does happen from time to time. But what we do have all the time is we have non-owned autos that are servicing the association. Could be the landscape contractor, could be the manager, could be a board member driving to the management company to sign a check. And maybe they're involved in an auto accident. And then through deposition, we find out that the board member was driving on board business. Maybe the association is going to get named in that suit. The non-owned auto policy will take care of that. Directors and officers liability, super important coverage for everybody serving, and that includes your directors. It also includes your committee members. And basically, it's defending you against accusations of wrongful acts. And so basically, here are some examples. Could be that somebody is at a board meeting and the board member is trying to make it so that kids are safe in the common area driveway. So they very well meaning put up a sign in the driveway saying no children playing in the common area driveways. Well, that's a real claim, by the way. And what happened on that is they got sued. They got sued under discrimination because children are protected classes. And I won't bore you with those details too much, but suffice to say, the policy did pay out. And the reason why is because it's covered under discrimination under directors and officers. Not every D&O policy covers discrimination, so you have to be careful with that. But that is a very common claim. Another one is a challenge to the votes. You have an election, and maybe someone's going to say, hey, the rules weren't followed, something happened here. That's another D&O claim. It's basically everything outside of bodily injury and property damage, and they usually stem from a decision or lack thereof that the board was to make. Another great example, if you have a view area, is a architectural application. Maybe it gets denied, somebody argues that, they take issue with it. That's typical D&O claim. So then we have the umbrella policies, and an umbrella policy, what it does is a lot of times people think it's applied to anything, and it's not. It's only applied to the general liability and your directors and officers. So for instance, if you have $1 million general liability policy and a $5 million umbrella, you have $6 million of coverage for that situation. So it just gets added on top of it. Same thing for the D&O. You have $1 million D&O policy, $5 million umbrella, $6 million of total coverage. Workers' compensation, a lot of associations don't think they need it because they have a situation where they don't have employees, but that's actually not the proper way to go. The proper way to go is to spend a few $100s a year on a workers' comp policy that picks up any incidental labor that you might have. So it could be a case such as came out of Los Angeles, where you had somebody who was hired to replace the rain gutters. They got injured. Turns out they had no workers' comp insurance. Turns out through the Workers' Comp Appeals Board, the management company and the association were responsible for those because California will look for an employer. And if the association has them there, it kind of some details here about being licensed and non-licensed, but that's what your workers' comp policy does. It also covers you as board members. So if you get injured as a board member, you can be covered under a workers' compensation policy. Cyber liability, obviously a growing industry. Basically, we put that on all of our policies. It is as good for just in case your system gets hacked and then personal information gets released. You want to make sure that there's possibly going to be some fines and some steps you have to take. There's a cost to that, and the cyber liability policy will participate in that. And of course, employment practice liability. Again, associations, just like the workers' comp, if they don't have employees, they don't think they need this. And that could be true, but you have to make sure that you haven't indemnified any vendors for their employees. If you have employees or you've indemnified others for their employees, then you need to think about having employment practice liability covers wrongful termination, sexual harassment, hostile workplace, failure to promote, things of that nature. So it's a nice thing to have. And the good news is that if you did take on that risk, getting an employment practice liability policy is very inexpensive. It's just you want to make sure you get it. So additional insured requirements, we have the homeowners are part of the policy, especially when they're in the common area. But what you have on additional insured is you have the general liability and the D&O, making it so the community manager has additional insured. So it's not just the manager, it's the management company. And that's going to be in every management contract you would ever sign. They're going to require that the association name them as additional insured. But here's what that means. What that means is that when somebody trips and falls, because again, that's the #1 claim, and then they sue the HOA, then they sue the community manager, and by the way, they sue the management company. Because the manager and management company have an additional insured endorsement, they're going to enjoy the benefits of the association insurance policy that provides them a defense. And so basically, if you're a realtor and you're either now or you're going to get into managing some properties, and this also applies, by the way, to apartments, you always want to make sure that the insured, whether it be the HOA or the apartment owner, have you named as additional insured so that you can get coverage and you don't have to rely on your own insurance or out of pocket to pay those expenses related to your defense. Super important to know. Under directors and officers, we covered a lot of it, but I will just say that it's strictly for wrongful acts and claims against the association and or board alleging negligence. So basically it's a situation where you're accused of really making an error. Happens all the time. So we insure about 700 associations. I'll guarantee you we have 2 or 3 D&O claims being filed per week. So it is something that's very active. And part of the reason is because it's a claims made coverage, which means that the policy that's in place when they make the claim is the one that responds to it, as opposed to an occurrence policy on a liability. If somebody fell down 2 years ago and you're with State Farm 2 years ago, and maybe today you're with Farmers, but they fell down 2 years ago, you'd call up State Farm and say, hey, somebody fell 2 years ago, please open this claim. Whereas if it's a D&O, it would be the new company would take it over because that's when the claim is brought to your attention. So it's a little bit of a difference in nuance there. Coverage can differ greatly from one policy to the next. So be very careful of that. Things such as getting the employer practice liability included, discrimination would be 2 examples of that. So you have to be mindful of that. On workers' compensation, as I said earlier with you have a situation where it's like, well, we have no employees. Why do we need this? And it's just the state of California will find you as the employer. So you want to make sure that you have this very inexpensive policy. It costs you about $350 a year. So it's not a big expense. And again, we've had board members that have been covered. I had one board member who punctured himself with a screwdriver in the hand. I have another board member that broke their ankle on a landscape walk. We've, not me personally, but I've heard in the industry of assault and battery victims. It's a crazy world. And so you want to make sure that if you're serving as a board member that you do have some coverage for that. But really, it's going to really, the genesis of it is that we want to make sure that if you get a certificate of insurance from your contractor, and maybe they miss the payment and then their insurance goes out of force, state of California will find you as the employer. You want to make sure you have a workers' comp policy to pick that up in the event that the workers' comp that you thought was enforced on the contractor is actually enforced or it's not. So that's the reason why you have to have that. CC&R language will be very clear on that. You should have it. And it's just something that everybody needs to accept and get.
As we've talked about, all the policies and procedures there, they include the policies that the HOA has. So if you get that information from escrow during the transaction process, you can sit down with a professional like Patrick and go over what policy the HOA has, and then thus figure out what policy the homeowner themselves are going to need. So again, this information is available there. It's available through the HOA. They'll give it to you through the process, and then you can sit down with a professional like Patrick or others who are licensed in the industry and have specific knowledge about HOAs. And, you know, it's such a specific industry that you really have to have it. So I no knock to anybody who doesn't specialize in this industry, but if you don't specialize in it, you're probably going to miss something. So again, I'll put it up there one more time, caioc.org. Look for Patrick on there or other professionals who can help you navigate the insurance prospect of that. With that, Patrick, thank you very much for participation today.
Thank you.
I always appreciate your insight. I've seen Patrick do that at least a dozen times now. I still barely get half of it. So it's really good information that I'm trying to absorb myself.
Well, thank you very much.
You're welcome. Thank you. So now we're going to finish off talking about the finances. And these are important for a real estate agent to know because this is going to have a direct impact on your sales process and, of course, how happy that individual is with their property. So there are some basic responsibilities out there. We've talked a little bit about the past, but the board has a responsibility to levy and collect associations. That's their general. Run the association. So they have these, they've given them to them by the governing documents in the civil code, and they have a duty to manage the HOA finances. It's not a good idea, it's, you know, should, it's a shall. You shall collect the assessments, you shall pay your bills, you shall operate it. So these are the fiduciary duties that a board member has when operating within an HOA. HOAs are corporations in most circumstances. You can find all of that information in the California Corporations Code. There's a little bit in the Davis Sterling, but there are a number of financial documents, balance sheets, income expenses, check register, reconciliation reports, etc. So if you want to find out the financial condition of an HOA, all these reports are available. They are available to the membership. Again, current reports are available to a current member within 10 days. Older reports may take longer to retrieve, but all of the information on finances is available to membership and thus to you. Other financial statements, a general journal entry report, which gives you the detail on what they are, the prepaid report, delinquency report. So association members can prepay their assessments if they so desire. The association has to take that money and then, of course, would create a prepaid report showing that liability to services versus the money they've collected. On the reverse of that, they have delinquency reports. So if somebody hasn't paid their assessments, then they keep track of that. Again, as Daniel talked about earlier, the board has a responsibility to go collect that money, but they'll keep that in a form. And so those are both there. The reason I bring these up for a real estate professional is if you take a listing on a property, have one of your members go get you a copy of the delinquency report. If it's high, meaning that there's more than 20% delinquencies, you're going to have problems getting financing in that community. We'll talk a little bit later, but FHA, most lenders have restrictions on what they'll lend on. One of the big ones is delinquency. If the HOA has trouble collecting its money, that can be problematic. They may have to do special assessments, etc. So they don't like that. So they have general limitations. So if you have high delinquency reports, you may have trouble getting financing for that property. So when you take a listing, ask to get a copy of the delinquency report, and you can head that off early and get that taken care of before offers start rolling in. So we have an annual budget. Associations work in fiscal years. There are, of course, 12 months in a fiscal year. So they have their annual budget known as the operating budget and then their reserve allocation. So the annual budget is all the things that you need, your utilities, your maintenance services, etc. So all the things the association has during the regular year. So you do that on anticipated income, anticipated expenses, and then, of course, the reserve allocation, which is the money that you're setting aside for future repairs or replacements of the capital expenditures. So what must be included? Estimated revenue on an accrual basis. Accrual is basically like a monthly. So cash flow would be like your checking account. You put money in, the balance goes up, you write a check, the balance goes down. Accrual method is all the assessments are due on the first, so you book all the revenue. So while the checks may not all roll in on the first, you know how much revenue you're due on the first. And the same thing on the expense side. While you may not pay your electrical bill on the first, you know that you have monthly expenses. So you'll book all of the expenses on a monthly basis. It allows a community member, and specifically a board member, to look at the finances in a clearer understanding when they're done on an accrual basis. And of course, it does require that you have the reserve funding, whatever it may be. As Daniel talked a little bit ago, we have limitations on how much a board can go with authority until they have to get membership approval. And it's typically referred to as the 20 and the 5 rule. So it's 20% of the regular increase. So a regular assessments, whatever that happens to be, you can increase it by 20% with a membership. Without membership approval, that's the board's authority. Same thing on a special assessment. It's up to 5% of the budgeted gross expenses. So those are the authorities that are limited to the board members. The association membership can, of course, elect to assess themselves whatever they want. The one addition to that or exemption from that is emergency special assessment. So the board does not have the 20 and the 5 limitation if it calls for an emergency special assessment. The caveat to that is it has to be an emergency. It has to be a threatening to life or safety in order to use that provision. So they're very rare, but those are the limitations that the board operates in to get membership approval, or to work without membership approval to increase the revenue. You have a reserve fund, hopefully, right? If you're an association, you are allowed to borrow from that. There are certain provisions, you have to notice it in the meeting, and that money has to be paid back within 12 months. So there are many circumstances where borrowing from reserves might be a good idea, but there are a number of provisions that have to be met, and of course, it has to pay it back. Good news is you don't have to pay yourself interest. You can borrow from your reserves without interest. A number of reports are required. There's an annual policy statement, an annual budget report, and a year-end financial report. So an annual policy statement is, like the name implies, it's all the policies. So all of the insurance policies that Patrick talked about a moment ago, and then all the operational policies that Daniel talked about a while back. So parking, permits, pets, all of that stuff is in your operational policies. That's part of your annual policy statement. All of your fidelity bonds, your property insurance, et cetera, are all part of your policies. That is included in the policy statement. And that has to be sent to the membership 30 to 90 days before the end of its fiscal year. Then you have the annual budget report, which is the pro forma operating budget, your reserve study, funding plan adopted by the board, assessment reserve funding disclosure summary that's required by the Civil Code. All of that information is part of that same annual budget package that we like to talk about. That also has to be delivered 30 to 90 days prior to the end of the fiscal year. They can be done in either a summary or a full report. Most of these statutes are written before PDF, so of course they wanted to save the hassle of printing up literally hundreds, sometimes thousands of pieces of paper and sending them out. So a lot of them just did summaries, but if you do get a summary and you want a full report, you can certainly request that and get a full copy. We talk about the consequences for failure. So everything in the Davis-Sturgeon Act is adjudicated by a civil jury, with the exception of this one. If you do not, as a board, give this financial information, meaning the 30, 90 days, you have lost your ability to raise the assessments. Yeah, let me repeat that. Is a board fails to do the annual budget report and provide its membership the financial disclosures ahead of time, they lose their authority to increase the assessment. So no longer do they have the 5 or the 20, they got a 0. They cannot increase the assessments without membership approval. So that's a pretty significant consequence that's already outlined in the Civil Code, and the only penalty that's already outlined. Everything else would have to be adjudicated. The year-end financial reports, that's 120 days at the end of it. And generally that is similar to an audit. If you have $75,000 or more in income, you're required to at least have a review by a certified public accountant. Most large associations and most fiscally responsible associations will go ahead and have the money and spend to have a complete audit done by a certified public accountant. But the minimum is $75,000 and you must have a review, which is a little bit less in scope. All right. Now we're coming into the final guest. They're talking about reserves, my favorite subject. So reserves are made up of 2 parts. You've got the physical analysis, which is the property itself, its physical condition, and then the financial analysis, right? How much money do you have? How much money do you have coming in? How much money you're expected to spend? So these 2 separate parts make up a reserve study. So made up of subcomponents. One is a component inventory, and that's a list of the items the association is responsible for. That's going to relatively stay stable, right? You have the same amount of roofing, you have the same amount of water heaters, et cetera. However, their condition will vary from year to year, right? So it's a year older, it's 2 or 3 years older. So the conditions will change from year to year. And of course, the life and valuation estimates. Remember, we have that wonderful thing called inflation. So a water heater, whatever it cost last year, well, this year it's a little bit more. If you're in LA County specifically, it's about 9% more. But nonetheless, every year you have to increase for new life valuations, which would include inflation and things that will vary significantly, like things that are based on commodity projects, such as asphalt, of course, is based on the cost of oil. So some years it goes up, some years it goes down. So you want to make sure that you're using current life estimations when you do that. And so that will change from year to year with each report. It has a financial analysis. It uses a term called percent funded. It's also known as a current status. And that's just where you are. So it's a usual mathematical term. So let's say hypothetically you have a water heater. That water heater lasts 10 years and costs $1,000. It depreciates at $100 a year. So after 3 years, you should have 300. After 7 years, 700, et cetera. So that's just a simple mathematical calculation. Now, with that said, when we anticipate a water heater lasts 10 years, well, of course, a water heater could fail before that 10 years. Of course, it can last longer than 10 years. There's nothing that requires you to remove a functioning water heater. It's just an estimate of how long they are so that they can calculate what's known as accumulated depreciation to see where you are. So again, on that percentage, 0 being the worst and 100 being the best, you can kind of gauge for yourself where that particular association is in their funding process. The other thing that is required is a funding plan, and that's the most important because that lays out how much the association is going to set aside each and every year in its budget to maintain the facility. And again, if you're starting off from a very low percentage funded, well, then that amount is going to have to increase significantly over time above inflation levels to play catch up. Of course, if you're starting at a well-funded level near 100%, well, then you can anticipate only inflation level adjustments. So it's very important to understand, one, where you're beginning in as association from your financial condition, and more importantly, what has been recommended or adopted by the board to fund their future needs. So we asked a few questions. It's basically, what's the association responsible and how do they pay for it? It's going to be broken down into several subcomponents. There are three particular services out there. A full study, as the name would imply, is everything. So the analyst goes out to the property, they identify the components, they assign them a life expectancy or remaining life expectancy, valuation, cost estimates, create a funding plan, the whole caboot and caboodle, as they like to say. Then there's an update with a site visit. If the property is done correctly, you only have to do a full study once. Now you've got the inventory of items. So now you go out on a cycle and you update that information. So again, the roof is older, maybe it's been replaced, whatever the circumstances are, you update that additional inventory with new information. And then we have what's known as an update without site visit, also known as a financials only or a desk consult. And that they're just going to update the life expectancies by reducing the number of years elapsed or changing the life expectancy if it's been replaced, create a new fund status and a funding plan, and give you that information. The reason that there's three is there's a different variety. So the requirement to conduct a visual inspection is at least once every 3 years. So that would be a number one or a number two. The study has to be reviewed annually, and you have to provide a funding plan adopted by the board. So you're going to need that desk consult or the update without a site visit in the years between the site visits. So every 3 years, you need to have a site visit, and in the year between, you need to have an update so you can produce your funding plan to be adopted by the board. This is known as the Assessment Reserve Funding Disclosure Summary. It appears in the Civil Code. It is a requirement for all associations to have this attached to their annual budget. And this gets the very detailed information. I will tell you, this should be your favorite document because it was created by the real estate industry. Yeah, they wanted to make sure that people who were investing and buying real estate understood the financial condition of the HOA so they didn't come back on them years later and say, I didn't know, and sue their real estate practitioner. So this information gives very succinct information about where the assessments are, how much is going to reserves, are there any special assessments approved, are there sufficient amount in the reserves to cover their expenses? If not, what special assessments may be necessary? And then it gives you a 5-year lookout on what you should anticipate the association and its funding level. So it's very succinct, clear information that helps protect, of course, consumers and the real estate lobby. Now you have to distribute a copy of the membership. So, of course, the board can adopt whatever funding plan they want. However, whatever funding plan they adopt, they have to share that with the membership. And by Civil Code, it has a lot of information. So, of course, you know, how much is the contribution rate? Are there any special assessments? Are we making any money on our money? How much are we going to spend on these components? How much do we have at the beginning, at the end of the year? And then it comes out to a balance that says, okay, are we above or below that? And it has that, kind of hard to read there, but it says a per unit. So the Civil Code requires that they let the consumer know on a per unit basis where the association is, because that's very important to individual members. Also put in there by the real estate lobby, and it appears multiple times. So this is a summary of a reserve study. Most of the information, again, is required by law. So you've got the basic assumptions up top. So the year that we're talking about, inflation rates, interest earned on your money, your beginning balance, and how many units are in that association. And then just the reserve contribution. So the amount that we're putting away to reserves is that middle portion, and then the total of assessments. So all of the assessments, including the reserve contribution and how that impacts. And then where you are, we talked about it earlier, that current status, the accumulated depreciation. So we show you that accumulated depreciation because, again, it's required by law. The overage or deficit. So in this case, you see here, it's $308,000 or $64.31. Again, that was put in there by the real estate lobby because in a hypothetical situation, if you see it, you go out to the properties, as we know, you take people around for 6 months, show them 900 pieces of property, they finally make an offer on one, you go back and forth, offer and acceptance, and boom, now you get your disclosure documents. And they see that this particular property that they love so much is $6,431 upside down per unit. So generally speaking, in the seller's market, you're not going to get any movement on that $6,400. In a buyer's market, maybe you get some movement on that $6,400. That's not important what happens in individual transaction. It's that that number get disclosed, because it will vary from transaction to transaction what happens with that number, where anything at all happens with that number. But it's important to get it disclosed up front so nobody can come back later and say, I didn't know. And then that bottom group, it gives you down there where your percent funded are. You see it says 35.81 and 38.58. So in this scenario here, this association is starting off at 35.81. So for every dollar they should have, they have 35 cents. If they follow the recommendation of this particular analyst, at the end of the year, they'll have increased that to 38 cents on the dollar. And again, I could show you other documents, but that would increase with time. So the idea is wherever you're starting off, whether it's good, fair, or poor, you obviously want to get to that 100%, and we'll show you how to do that with that funding scenario. We have one of the most powerful lobbying groups in Sacramento. We in the reserve industry, I mean, you've probably heard of them. They're called the California Association of Realtors. And they pass laws that require people to have reserve studies and get financial information so that they can make informed investment decisions. And despite all of our powerful lobbying, there are still a few exceptions for people who don't have to have reserve studies. One is commercial and industrial. So commercial and industrial space does not require reserve study. That doesn't mean it's not a good idea. So any of those that you work in that space, it's good to understand financial, but it doesn't require it. On the HOA side or the homeowner side, it only requires a reserve study if half the assets or the assets are half of the gross budget. So hypothetically speaking, if an association brings in $100,000 a year, if all of their items that they are maintaining, whether it be parking information or a clubhouse, et cetera, if that is less than half of their gross budget, then they're not required to have a reserve study. I can tell you there are very few associations that fall in that class. It would typically be a planned unit development that has like a small pocket park. So they have a large budget because they got a lot of homes and landscaping, insurance, et cetera, but they only got a small pocket park, so they don't have a lot of assets. So there are a number of associations that will fall into the exemption, but generally speaking, that's for a PUD. So if you have a condominium, townhouse style structure, then almost absurdly, you're going to require a reserve study because the assets are going to make up more than half of your budget. The calculation methodology can be confusing. So it's accumulated depreciation. So we see here in our example, we got a roof, last 15 years, it's got 5 years remaining. So the cost of that roof is estimated at $20,000. The annual cost is nothing more than that $20,000 divided by the 15 years that it lasts, or $1,333. The accumulated depreciation is that $1,333 by how long it's been in service, which is 10 years. So at this point in time, the accumulated depreciation, or the 100% funded balance for that roof, would be $13,333. Same thing with a water heater. It costs $1,000. It's been in service about half its life. So you would need about half of its life expectancy and cost. So at this particular point in time, if this association has $13,833, then they're 100% funded. They don't need the $21,000 because they're not expected to need that for several more years. The other important number to look up here is that $1,433. That's the annual depreciation. So every association is going to have a reserve study, and all of them are going to show what that annual depreciation is. That should be at least the goal for the contribution rate, because if you're putting aside more than $1,433, now you're playing catch up. And so whatever you were under 100%, you're playing catch up and getting there. If you are below that, then you're falling farther behind. So if you're already in a poor position and you're not at least putting that much away, you're going to continue to fall farther behind. So it's very important to know what that annual depreciation is, because that would be the goal to put away at least at a minimum so you don't fall farther behind. All right, who can perform a reserve study? Well, technically anybody, because it's not a regulated practice. So technically speaking, you could have the community manager do it. I wouldn't recommend that for a couple of reasons. One, they're probably not professionally trained to do that, and they're not going to be able to do a very good job. What about Harry in Unit 3B? Okay, well, maybe Harry's trained in that area, maybe not. The problem with Harry in Unit 3B is because he doesn't do it professionally, he doesn't have any designations, doesn't display that he in fact knows what he's doing. And the second thing is the fact that he doesn't make any money, he probably doesn't have any insurance. And of course, I know you listened to Patrick and know the very importance of making sure that your vendors have insurance, both professional liability, general liability, and workers' compensation, because if they don't have insurance and something goes awry, it's going to be the HOA's insurance who winds up covering the bill. All right, so we got the two parts. So the site visit, they're going to go out to the property and they're going to identify the components and they're going to put them into some kind of inventory. You see this one here is generally done systemically, so roofs, structure, paint, etc. It shows you the approximate quantity that we're talking about, the life expectancy, both the useful and the remaining, the amount of that particular cost in today's dollars, annual depreciation, and a whole lot more fun numbers. So it will give you a general idea of what is being allocated for. And if you don't have any specific information, almost all of the studies, particularly those that have an update with a site visit, will have photographs and more detailed information on each component, its function, its usage, and where it may be located in addition to its condition. The Civil Code requires that we look out 30 years. So when we talk about funding plans and all these issues, anything with a life expectancy of 30 years has to be included, and our funding scenarios have to be extended out at least that long. So you see here, most of them are going to be driven by what we call a annual expenditure schedule. So you see here, HOAs spend money erratically, right? Some years you have a lot of expenses, you're replacing a lot of items. Other years you don't have so much. So you see in this sample here, it goes 12,000 and up to 118, back down to 0, up to 35,000. And they're all going to do that. I will tell you that every association of every type, quite frankly, every building of every type is going to have what we call our wow years in there. And so if you look out at 2034 and you go all the way down and you look and go, oh, wow, $658,000. So an association that's spending 12, 15, 20, a high year for them was 100,000. All of a sudden they've got a $650,000 expense. And obviously, if you looked up the categories, it's going to be a plumbing or, a roof or other major components. So every component, every property out there is going to have these list of components that eventually are going to come at a single year with the larger ones or just a significant number, and they're going to drive that number. So a lot of the monies that we're setting aside here in 2023 are helped to build up for that massive expense that we're expecting in 2034. So now we create our funding plan. And so we take our spending analysis, right, our component replacement, and we schedule that right into our component costs. So you see on that line item B there. So I've just literally taken that schedule of the component costs that we anticipate, slid them into line item B, and that gives us the idea because we know what we're starting off on our balances, and now we know what we're going to spend. So this is going to tell us how much we're going to have to collect over time to make sure that we have enough money to meet our obligations. And that's our funding analysis or our funding plan. We talked about this just a moment ago, but the association has that 20 and 5 rule. Well, it has an opportunity to play catch up. So if you're behind, you can see here in this, we've got operating expenses of $90, reserve contribution of 10, it's $100. So the 20% of that is $20. So you can increase your reserve contribution by 200% just by increasing the assessments within that 20. So there are provisions in there, you can do the simple math. It starts off at $100. Okay, well, then it goes to 120, then it goes to 144, then it goes to 172, and then it goes to 212. So in a 4-year period, you can double your assessment amounts. And of course, knowing that inflation is not that much, it's going up and it's high right now, but it's not that much. You can double your assessments within 4 years. Certainly, you can start to play catch up on your reserve contribution rate. Now, whether you want to do that is a whole nother subject. So this illustrates what the problem is when we never raise our assessments. So we see in this category here, we have our total assessments, our operating expenses at $90 and our reserve contribution at 10. So that says we should collect $100. Okay, terrific. That's what they adopted. All right. And then my never raised dues got on the board and he says, okay, so we have inflation. So now, of course, our operating expenses have gone to $92.40 and our reserve contribution recommendation is now $10.60, which is $103. But remember, Mr. I never raised dues is on the board now, and so they didn't raise the assessments. So ask this in yourself. You know what happens to a condominium that doesn't pay its landscapers? You know what happens to a condominium that doesn't pay its insurance company? You know what happens to a condominium association that doesn't pay its water bills? Yeah, same thing happens at your house, is they stop coming, they cancel your insurance, and they shut off your water. So, of course, associations pay those expenses. Those that have to be paid, they'll pay. And then, of course, they put whatever left over in the reserve contribution. And they do that for another year, and it goes up to 106. So now, once what started off as $10 to the contribution rate is now $5.60. So they're going backwards. They're actually putting less away. And you can see it doesn't take very long when you go for a period of time without raising your assessments, that inflation will continue to eat up more of the operating expenses, leaving less to put in reserves. So after just a few years, you could fall drastically behind in your reserve funding. So as we talked about, you have to distribute a copy to the membership. Whatever it is the board decides, it's within their purview. It could be a lousy idea, it could be a great idea, but whatever they have chosen, they have to do it at an open meeting, and then they have to distribute that to the membership. And then last and not least, this is the one that I think you guys should focus on because it's yours. And this is the document that we talked about a moment. It gives very detailed information on where the assessments are, how much we're putting in the reserves, etc. Now, this document is available only if you've had a reserve study. Of course, if you don't have a reserve study, it's going to be a bunch of zeros. You don't know what it is. It's zero. It's nothing. I don't know. Now, that's possible. Of course, you all are familiar with the California contract, and it has an exemption there that, hey, you know what? We think a reserve study is a good idea. It's very important, but this is a 3-bedroom, 2-bath in a great little neighborhood. So I'm just going to buy it anyway. I don't care. So you're going to invest in the association and then find out later that you get a special assessment. And then what happens, and I see this all the time, hundreds of times a year, is they get that surprise assessment. They weren't prepared for it. And then they start thinking, well, who could have told me that? So while this document will give them great information to make an informed decision and keep you out of liability, the waiver on the California purchase contract will also keep you out of liability. The one difference between the liability waiver and this document is that this one comes with referrals. Yeah, the people who discover the liability because they signed a waiver and they get hit with special assessments later, they're none too happy about that. And I can see their look in their eyes. They're none too happy with the real estate professionals. Thus, they don't call them back. Whereas the people who do get this information, who do have an opportunity to make an informed decision, they're generally happier with their purchase decision and thus will call the real estate agent back. So what I tell real estate community is don't let an HOA take away your referrals. Don't let an HOA be derelict in its duties by not providing the information that it is legally required by law to provide its members and thus its prospective members, and let them take away your commission. If they don't have a reserve study, just let them know that you want a reserve study, your members want a reserve study, and they will get you one because, of course, they have no defense for not having one. So with that, I believe we are straight up 11 o'clock. If you have any questions, please feel free to open them up into the chat room. I will be here for a few minutes to answer those. Please go to the chat box and download a copy of this so you can keep it for your records. And most importantly, a copy of that Davis Sterling Act. Save you $20, by the way. That's a $20 item on Amazon. So if you get a copy of that and you have a question as it relates to HOA law, practice, etc., you can find out the details in the Davis Sterling Act. And then, of course, last and not least, you can contact Community Associations Institute Orange County chapter to talk to a professional to help you guide you through those important aspects of selling in an HOA. So with that, thank you very much, Patrick. Thank you very much, Daniel. And thank you very much for all of the participants today for coming and listening to Community Associations Institute, what every realtor needs to know about home common interest developments.